So hello, and thank you for joining us for our newest edition to our webinar series, what to look for in a claims file. My name is John Blake, and I'm the Director of Sales here at Gemini Legal. Before I get to panelist introductions, I'm going to cover a few housekeeping items. First, this webinar is approved for 1 hour MCLE credit. In order to qualify for this credit, you'll need to be logged in for the entire session. If you have any questions for the panelists, there is a Q&A button on the bottom of your screen where you can type in your questions. We're going to try to get to as many as we can, and hopefully we'll be able to get to all of them. Also, you're able to find all of our past webinars as well as interviews and podcasts on our Gemini Legal YouTube channel. We strive to be a great educational resource for applicant attorneys throughout California. And joining me today, we have two fantastic panelists to share some of what I think is very useful information that can help your practice. I'm going to let them introduce themselves, starting with Amanda.
Hi, I'm Amanda Poe. I own a practice in San Francisco. I took over the practice from Michelle Brody, who some of you know. She's my aunt, so no bad blood there. She's just chilling in Montana most of the time. I've been practicing in workers' comp exclusively for about 10 years, always as an applicant attorney, and I'm happy to help answer your questions today and afterwards if you need to reach out. If you have other questions, I'm always happy to help.
Awesome, thank you. And now Jesse.
Hi, I'm Jesse Marino. I'm primarily an applicant's attorney, but some of you out there probably know that I do defend some uninsured employers at times. And I've been in the workers' comp field since like 1998, around there. I used to work for Industrial Indemnity, so that aged me a little bit, and various insurance companies. The last one, the Hartford, but I've been in practice for almost 20 years now as an applicant's attorney. Well, that's pretty much it.
Awesome, thank you. All right, so why don't we just jump right in? So Amanda, the first question I have is for you. So logistically speaking, what do you do in terms of ordering the claims file after the application is filed?
Yeah, in my office, I'm going to meet with my injured worker. We're going to have a full discussion about what's happening, what's going on, what my plan is. I know I'm going to need the claim file in 100% of cases. I file my application and I include a letter, and that letter is going to have a demand for everything in it. And that letter has expanded over the years to include more and more things. I give the carrier 30 days to produce that on their own without a subpoena. If I don't get the claim file or I receive an incomplete claim file, then I will act to actively subpoena that, and I will relist all of the things that were in my demand letter and ask for my copy service to give me all of those records that I am seeking.
Great. And then I do appreciate you sharing that letter with everybody. I did include it in the reference materials. If anybody didn't get your reference materials, you can reach out to me and I'll get them for you. Go ahead.
Yeah, I was just going to say, I just wanted to note that there is a regulation, and it's regulation 10101.1. And that regulation is going to tell you all of the things that have to be in the claim file. And that's going to be a list of 15 different items, A through O. And just to give you an idea, like one of those says all notes, correspondences, and documentation, including correspondence to or from any individual or entity related to the provision, delay, or denial of benefits. So you can see they're very broad, big category things, and there's specific things also that are in that. But you can check out that regulation to see the full list if you want to formulate your own demand letter and or articulate your subpoena a little bit more defined that way.
All right, good, thank you. And then before the application is even filed, while the injured worker is still considered pro per, Jesse, what types of things are you looking for that might have happened that you could find in that claims file?
Well, probably the first thing that happens is somebody called in to a call center and reported that injury to an insurance company. And if somebody typed that up into a note and sent it to some claims unit, and I've gotten some of those in the claims file. When you have it, you know exactly the date of knowledge and you know what was said to the insurance company as far as reporting the accident. So We rarely get those, but I get them every now and then, and it's helpful. We'll talk about it later, but there's the employer's first report of occupational injury, the 5020 form has a lot of information. There'll be letters and notices to the applicant as far as their rights. Well, we can see if the MPN was set up correctly, if proper notices were given to them, when the claim form was actually given to them, and sometimes you'll find a report. The claims adjuster will ask the employer for a report of the incident report of what happened, and so that'll be in the claims file as well. There's a lot of little things that happen in a claims file before we start hitting application and pleadings and things like that, and they're very helpful for us with regard to knowledge, data knowledge, and injury, and sometimes there's information there which we'll see too with regard to third-party issues.
Okay. What type of third-party issues?
Like for example, on the 5020 form, you might have that there's some machinery involved in the accident, and so to an attorney should prick your ears up. Like if there's machinery, maybe there's some product liability. It'll tell you where the injury happened. It might be at another premises other than the employer, so you might have some premises liability issues. There's a lot of information there that you can collect for auxiliary types of claims, other types of claims beyond your workers' compensation case. So
I know we were going to hit the 5020 form a little later, but since we got into it a little bit, so it's the Cal OSHA 5020 form. I did put it in the reference materials. And you said it's often in the claims file, but it's not discoverable for some things, right?
Well, I get it in the claims file and in the employer file, and you're not supposed to use it to prove you're not supposed to use it to prove injury, AOE, COE. Okay, it's excluded for that. But it's signed by somebody and it describes the injury. And so I've had instances where I'm at trial and I have somebody testifying that they had no knowledge of the injury beyond 30 days, 40 days, which kicks us into this disputed period. But I have a 5020 form signed by that same person that they actually knew about it at a very earlier period. So I might have that person on the stand and ask them questions about it. And then I'll ask them when they had their first knowledge. And if they lie, then I have a form signed by them under penalty of perjury, and that has the same language that the claim form has about the fraud. It has all that fraud language on that form. And I can bring in the form at that point with regard to impeachment, because that person is lying to the court. And, once the form's in there, the judge is going to read exactly what they knew, what date they knew it, and you get a lot more information in the evidence than you would have been able to have otherwise. But
Jesse, how often do you actually see that just provided to you?
90% of the time it's there.
Okay.
Wow.
It's just there all the time. And the reason is, from my insurance background, I can tell you that the person that copies the claims file typically is just a clerk. They don't look for that, and they're not trained for that anymore. They used to be, but they're not trained for that anymore. And the employer doesn't know any better. So the employer just sends it. And so you'll get it in the employer file, and then the employer will send it to the claims adjuster. Sometimes I see it twice. I see it when they said it the first time, then I see it again. So it's there a lot, and there's just so much information. And the form is very organized. You can look at on the left-hand side, you see it has employer information, injury information, the illness information, which is the what exactly happened, the description, has wage information, has occupational information, obviously data knowledge, and they're supposed to do it within 5 days. And then if there's a change, like if it becomes a drastic issue, person died, or they're supposed to amend the form as well.
Okay.
So it has a lot of information. If you look at the very bottom of the form, there's some regulations that refers to another form. It's the 300 form, which has a list, which is also discoverable, a list of other accidents that would have happened for that employer. And on that list, it's interesting because if you have a whole bunch of accidents on the same day, you might have witnesses there to your accident, other people that were injured at the same time. It also would help you in a serious or willful claim if these types of injuries have happened various times with the same machinery. You're going to see it on that log. It's a 300 log, and it says it on the bottom of this form that they're supposed to keep that log of those other injuries, and it's discoverable as well for us.
That's so cool. That's a lot of stuff. So you find a lot of attorneys just kind of dismiss it because it's not discoverable, or?
I find a lot of people don't know about it. They don't realize that it's a function that's happening in the workers' compensation claim before it gets to what we do with the workers' compensation claim. Because this form is really set up so that Cal OSHA has information about how accidents happen, what type of machinery is used, what type of ladder, are people falling off roofs, do they need to be strapped in? And that's how they promulgate their regulations, by using this form to collect a lot of data. And that's why they get that from the employers. And that's why it's because they want employers to be honest and truthful on these things. That's why they don't allow us to use it with regard to AOE, COE, because they're trying to data collect to save, other people from having the similar injuries. But a lot of people don't know that that's happening. These are steps that actually happen before the claim form even has to be given to the applicant. This is supposed to be done like right away.
Got it. So Amanda, if you see that a QME appointment is pending when you get that claims file, what can you do?
Yeah, that is something that happens all the time. I'm going to get a claim file and I'm going to see that discovery is progressing in a direction that maybe I would not have elected had I been there a little earlier. And, applicants are coming to us the day they get hurt, 3 years after they get hurt. So you have all people in all phases. There's no real commonality for me. It's just all kinds of time. So I need to know if they've seen that doctor before or if they have not. If they have seen that doctor before, buckle up, that's your guy. And you need to just figure out what your strategy is going to be, whether it's a rebuttal or an extra specialty. But if the applicant has not seen that doctor and the appointment is pending, you are at a critical phase and a critical opportunity to change that specialty if it's not appropriate. So you can look at that appointment that's coming and it's a great tool for applicants' attorneys, and it's so easy and straightforward to do. You write to the medical unit, you say, per the Romero case, we need a different specialty. This is the specialty that I would like to elect. You attach your QME form, I think it's 106, where you list out the QME that you need and why you need it. You must say in that letter that your applicant has not already had an evaluation with the QME. Otherwise, they'll send it back to you and you'll have to repeat the process. But if you can confirm that they haven't gone and that it's not the specialty you want, it's almost guaranteed that you're going to get your new panel issued, and then you can start the process fresh with your 10 days to strike for both parties, and you can send that out. And you can just disregard the prior panel that was issued as if it never happened.
Nice. And I did put the Romero case in the reference materials as well. Hey, Jesse, just so we don't get too far away, we did get a question. Is the 300 log a part of the 5020 form?
It is not, but the regulations are referenced at the bottom. I think it's CCR 14300.5. And if you look that up, you're going to see that it has the summary of the other injuries that employer has had throughout the year, which you can use maybe for an S&W claim. If you request it, you're supposed to get it next business day. That's what it says on the bottom of the form. It's just, that's never going to happen. And then it has the names of other employees. There are some exceptions with some injuries because of HIPAA and things like that, but very few. And so if you look at CCR 14300.5, it'll explain it to you. But just type in Cal OSHA 300 form and you'll see what the form looks like. It's basically a log of injuries, and it has the other employees' names.
That's great. All right, cool. So Amanda, I understand there's some things that you look for in a doctor's report that's in the claims file. Typically, what are you trying to find there?
Yeah, so let's say that your client has not yet gone or participated at all in the QME process, and maybe there's not even an objection yet. You're just getting some medical records. There are a lot of things that you could find in those medical records. So I wrote a short list. You could find ratings that you could use to go ahead and have a settlement discussion. You could find a rating that you need to object to get you on the QME panel process. You could also find things like a discharge from care, which would make you want to start the QME process. You could also find things like factual inaccuracies. Maybe there's something in the medical report that doesn't line up with what your injured worker told you. You could find body parts that you haven't alleged in your application that maybe need to be included in your application. You could find information about prior accidents or injuries that they've disclosed to this doctor that they've seen. And from a strategic standpoint, you could also find information that perhaps would make you reconsider whether you filed it as a cumulative trauma or a specific. Maybe the medicals look like one more than the other, because your injured worker is not going to be super informed on the difference between that. And so sometimes the medical records make one of those clear. Maybe it's two specific injuries instead of a cumulative trauma, something like that, that you haven't fully hashed out. Most commonly, the claim file is giving you your first opportunity to object. That is your first opportunity to get to a QME panel. From people that I know that are applicants' attorneys, I would say some people are of the mindset that you get a QME as soon as possible. You get your claim file, you find something objectionable, and you start that process. For me, sometimes I tend to elect my own treater, see what the recommendations are for that. And then based on those recommendations, that's when I begin the QME process after I've elected a new treater. But I don't think there's anything wrong with either of those strategies. I think they both have merit in terms of how you practice and how you get things done. But just know that when you're objecting, you can object to ratings, discharge, causation, body parts that aren't included, or your treater refuses to treat them. You have a lot of options for things that can be objectionable that can get you to the QME process, which frankly will litigate anything for you once you get that QME. I just wrote a couple other notes to expand. I just want to point out that my clients will tell me that they said something to the doctor and then that's not in the doctor's report. And I just want to be super clear that federal law and California law permit patients to review, receive copies of the reports, and make amendments. So theoretically, it's not too late for your client to write to the doctor and say, hi, I told you my left arm was hurt that day, and you have not put that in the report. And I'm asking you to make that amendment to the report because you left out these body parts that I discussed. Because years later, somebody's going to point to that report and they're going to say, well, he didn't complain about his left arm when he went to the doctor that morning. And that can create problems later when at that time that medical is actually factually incorrect. And so you have a lot of legal right to change that. And so I think it's important that your client does that if it's something that's really like at issue for you.
How long after that report's written can they ask for an amendment?
It's a great question. I'm usually only asking my client to do it if we're talking about a report that was generated in the past month or two. But I don't know off the top of my head what the longest you can go to get a factual correction to a medical report is.
Yeah.
And then lastly, I just wrote that if there's a rateable report in there, and I'll talk about it more because we are going to talk about settlements and things, but sometimes there is a rateable report, and sometimes you can just tell that injured worker like, hey, listen, this is a respectable physician. He's given you this whole person impairment. This may be a realistic outcome of your case anyway. And you can use that to give them some options about what may be coming down the pipeline.
Mm-hmm. Yeah, I would imagine sometimes it's difficult to get their mind around what a reasonable expectation is, right?
Yeah, and it's a great place to start.
Yeah, sounds good. Jesse, anything to add to that?
Just from a claims files perspective, you were talking earlier about like especially with the Romero case, invalidating the panel. Sometimes you'll see in the claims file, you'll see prior to our representation, the adjuster has sent the advocacy letter to the PQME, and that advocacy letter was not copied to the applicant. And so that is the reason to strike that panel, because the applicant in that point, they're in pro per, they're entitled to know any communication that's happening with the QME. So I've seen that a lot. So you just look to see on the letter, see if they were CC'd. If they weren't, then they probably didn't get that letter, raise that issue. And sometimes they are copied, but the letter will be so general that it'll say, we're also providing records for your review, doctor. And it'll just say records for your review, but no list, no index. And so again, the applicant doesn't know what records are being produced to the doctor, so they have no idea. And so they don't have an opportunity to object to that. And so those are ways that you can use the information in the claims file even after they've gone to see a QME. If it's not favorable, you can seek to have it stricken because of the lack of communication to the applicant while they're in pro per by the claims adjuster.
Okay. And then that would be a replacement panel in the same specialty.
Correct.
Okay.
Yeah, correct. So
Cool. I did get asked what that CCR code section was again, Jesse, if you have it handy.
CCR 14300.5. If you also just Google 5020 form, you'll get the 5020 form, and on the bottom there's a whole bunch of CCRs that you can look up.
Okay. Yeah, if they look at their reference materials, they'll see it there.
Yeah,
That's
yeah.
cool.
Right on the bottom of the 5020 form, you'll see a whole bunch of CCRs there. Those are the ones I'm discussing.
All right, good deal. So Amanda, if there was a settlement offer in the claims file, what can you learn from that? And are there any red flags you might see?
Yeah. So this one is a true story that it's very brief, but an example of one that I got was the carrier's offering something like $5,000. And I say, okay, well, let's take a look at it. And the case is now denied based on the fact that they were recommending surgery. And my client said he didn't want to pursue the surgery. So the doctor discharges him, they deny it, and then they're just making a nominal offer to him now. So that's absurd. This guy is like in need of surgery at this point. His decision not to have a procedure doesn't decrease the value of his case. It's probably, in some cases, could make it worse for them. You know, he's going to be limping around on this knee that actually needs some kind of treatment. It's going to spread. It's going to be terrible. That's the kind of thing where when I see that settlement offer, I know we can move on. We need to do discovery. We need to just move forward. That can be contrasted with a doctor that I respect, think is a good job. My client gets lucky and they're in treatment with this person. They're giving me an estimate. The STIP offer is based on what that report says. That might be a really realistic thing for my client to consider. I might say, you know, we've got a Dr. Campbell report that's worth 10%. If you want to go down the QME road, I can't guarantee that it's going to be more than 10%. If this is the only body part that's affected, if this is an accurate description of it, if this is a realistic list of your symptoms. And so the red flags can come when they're based on really ridiculous things. And then sometimes it's green flags if I think, hey, look, this is giving us an idea of where we can start. That would be a time also where I talk to my client and say, look, they're offering you 10% for this knee injury. How's everything else going? What's the other body parts going? Is there anything your doctor missed? Is there anything that we didn't cover? Is there a period of temporary disability that remains unpaid? Maybe the 10% STIPs are fair, but the carrier has overlooked the fact that there were 6 months where no one paid the injured worker. And so that kind of thing can come up where the settlement offer is there, and it's not blatantly unfair. It's just missing other details and facts and body parts that maybe should be covered in future medical. And I see that still as me doing my job, even if we don't elect to do a lot of additional discovery.
Sure. Okay. And then Jesse, you mentioned to me that you look for any recorded statements in the claims file. What might those be, and what will you do with those?
Well, a lot of times the insurance company will send an investigator out to the work site and take recorded statements from some witnesses that may have seen the accident, and they'll take a recorded statement sometimes from the applicant of what exactly happened, and we rarely get those in the claims files. And so then I'll talk to my client a lot of times, either at intake or right before a deposition, and I find out that there's a recorded statement. Well, I don't want a deposition to go forward until I have the recorded statement, and a lot of times I'll get it on that day and I'll go over it with my client before the deposition. But the applicant's made a statement there and it's written down, and sometimes they have them sign it, and we're entitled to have that information that the applicant provided. We're entitled to have anything that the applicant signed that's in the employer's file. If the applicant signed for something that's in the employer's file, we're entitled to have it. And so, but a lot of times it's not produced, and then you can find witnesses there as to what they say happened. They might have had a different angle of the injury than the applicant did for various reasons. And so those are very important. And if these statements were taken early on in the case, they're not work product of an attorney. And so we're entitled to those statements. But there's the hardest decision. It's still out there. It's still good. And we're entitled to have these statements, but we rarely get them. It's a big battle on the files a lot because they're not there, but there's a lot of information there. That's the most contemporaneous information about the injury that you're going to get is the statements that happen within a week of the injury. Sometimes it's the same day. I had a client one time where recently that he told me there was a recorded statement. They're telling me, no, it didn't happen. His daughter, who's a lawyer, was with him while they did this recorded statement. And the adjuster called on the phone and had this conversation with him in front of the employer on a speakerphone. And so that's how it all went down. But adamantly, the defense attorneys told me, no, there's no recorded statement. And I said, I'm not going forward. We can go to trial on this issue. It's crazy. I mean, it's not just my applicant telling me now that it happened, but they'll say, no, he doesn't know what he's talking about. There was nothing happened. And whenever you call an insurance company and they have you on a speakerphone, they're recording everything that's being said.
Yeah.
Everything. So there is the recording somewhere that we're entitled to have.
Yeah, I
And
just
that's
want
happening a lot more now, where they'll call and do recorded statements on the phone where they're not doing it in person. They used to do it in person a lot.
I just want to add that I wrote specifically what you're addressing now, El Pollo Loco v. WCAB. That's like a 1998 case, and the applicant is entitled to a copy of her own recorded statements before deposition. And then there follows a panel decision, Armando the Endodontic Associates Corp. And that one, the appeals board also concluded that the applicant can require the production prior to the deposition. I did find in my research that you may not be entitled to those witness statements prior to the deposition because the court said, sure, you can refresh your memory from anything you signed, you said, but maybe we want to see your version of things before we let you be influenced by what other people witnessed or observed. So that one is, I saw some maybe, back and forth on whether the case law would permit that one, but no debate that you can get your own statements.
A question for you. Amanda, you put together this great letter. You've changed it and made it better over the years and all the rest of that, and you send it over to them. How often do they just send you the claims file, and how often do you have to subpoena it? And as an add-on, how often do you get the whole claims file with everything you asked for? And how often do you have to subpoena the rest of the stuff, right?
Sure. In terms of what I get, I was actually thinking about that in prep for this, like what my answer would be. Getting something at all. Lately, I'm at only about 50% of the time on that 30 days. Do I have anything that would even qualify as a claim file, which I think is low. And then in terms of that 15 part list where I've been served every single thing in that, I'm going to give it a solid 0%. Maybe there's been some good jobs out there and I'm not giving them credit. So maybe 5% of the time I've received a full and complete list of all of those things. I think it's incredibly rare. So whether I need to push it or not is going to be fact-based. I do not issue a subpoena for the claim file in every single case. Sometimes I get a pretty thorough file. It's covering most of the issues. My client's not telling me that there are wage issues, that there are employment issues. It seems like everything's going really well. I reserve my resources for working on things where I think that there might be something that's at issue there, a denied case, something that's going to need me to make that extra push for it. But my personal practice style, I don't subpoena it every time.
I know things are often different from Northern California to Southern California. So same question to you, Jesse.
Well, that was a long question. Let me see. What?
So
I get everything. I'd say 50% is a lot that I would get something with
you get something. Okay.
Did I get everything? Never. I mean, I know. I worked in 3 different insurance companies. I know what's in those files, and I know I never get it all. And then Amanda's right. You got to pick your battles because is it important to your case? Is it not? And so sometimes you want to go through the whole fight. Sometimes you don't.
What percentage would you say that you'd send a subpoena on if you didn't get it sent over?
What's that?
What percentage do you think you send a subpoena on if you don't think you got the whole claims file?
Did I follow up for more?
Yeah, how often?
A lot of times it's not a separate subpoena, but I'm litigating the issue. I'm going to court about it, saying, hey, I issued a subpoena, they haven't fully complied. I know there's other records because sometimes you might have a letter referencing another letter and then that other letter is not there. And look, sometimes you need to buy more time, and sometimes that's the way you buy more time in the litigation
Yeah.
process. You say, haven't had discovery given to me, and you look and see what they gave you in the claims file, and you make that argument to buy yourself more time on other issues, and you have the right to do that because they still have to comply with the subpoena. Back to the issue about when they comply with providing some records before the 30 days. That's all well and good, but nobody's signing under penalty of perjury. That's the whole record, and that's not going to be good enough for me. I want somebody to sign that I can put on the stand and ask questions about whether they've complied with everything. And then a lot of times you do get compliance after the 30 days, after the subpoena is issued, and the defense attorneys will show up to court and say, yeah, we've complied, we've given everything. And I go, yeah, but you didn't give me the certificate of compliance. So you didn't sign that under penalty of perjury. And that's not full compliance. Or sometimes they'll say, we gave you everything that you're entitled to. Whenever you hear everything you're entitled to, that means they didn't give you something. And so the rule is they should have a privilege log that states what they didn't give you, so that we can go over it and see if I really am entitled to it or not. The decider of who's entitled to it or not is the judge, not the person that's withholding the information. And so these are little buzzwords that you get all the time. You get everything you're entitled to. If you hear that, that means there's more. And you need a log.
Yeah.
So Amanda, I had somebody send in a question. Can you repeat the cases you mentioned about the applicant statement obtained before the depot?
Yeah, sure. And I'll type them in this chat group. That way I can get it right.
All right, good deal. By the way, I noticed a couple people raised your hands. That isn't going to help us here. If you have a question, please just put it in the Q&A that you see down on the bottom of the screen. It's actually right next to the raised hand button there. So, and we're happy to answer any questions. So cool. Sometimes the employer sends the personnel file and it gets included in the claims file. What can you find in that can help your case? And Jesse, I'll go ahead and start with you.
I didn't get the first part of the question.
Sometimes the employer sends the whole personnel file included in the claims file. What do you look for in the personnel file that can help your case?
Well, there should be MPN notices and all those types of notices that they're entitled to have. But also in the employer file, you should also have other injuries, other claim forms, other things that have happened before your case that might be important. If your client's been out for a long period of time, if you see a big break in payroll, either before or after your injury, if you have a CT or things like that, those might be indicators that a CT was starting. So their tardiness, because they have to go to a medical appointment or something like that, or they took time off because of a medical appointment. There's a lot of that communication back and forth. You can also see the reviews of your applicant. They might have had really good reviews, and all of a sudden there's a new supervisor and there's a big problem. Sometimes that comes up in the cases, and you can see the timing. You can see timing when things happen in the employer file a lot. Yeah, so you'll see a lot of comments. The employer file is a little bit more raw. You're going to see a lot of handwritten notes and things like that from employers, and they're not, they're just dealing with their employee. They're not thinking litigation. They're not thinking things, but there's some information there that's important. But certainly back to something we talked about earlier. Anything your client signed, you're entitled to have a copy of it. And so if they said anything to your client, they had them sign for it, you are entitled to a copy of anything that was signed. So.
Yeah, I wrote that one of the things that has happened before is looking for their most recent raise, because that raise can indicate an increased TD rate that, their average weekly wage doesn't reflect. Because if you look at their average or their W-2, you might see $30,000 last year. But if in the month right before they went out of work, they were promoted, they got a raise, something like that, you get to make a demand for the TD rate at that increased rate. And your client doesn't know that. Sometimes they'll mention it, and that's great to ask, but you can find that there. I've also had times where disciplinary notes existed post-injury. They're getting written up for things like tardiness or taking a lunch break for too long, things that are maybe legitimate on their face, but when you look at, years of work history, they've never been written up for anything before, those might be able to justify a 132A. And you can show that maybe this person is being discriminated against. I have an injured worker who years ago now, she's gets her injury and then everything changes. But when you go back in the personnel file, you can see that her reviews are stellar. Every review is like well-performing, great, we love her, post-injury. She doesn't have her keys on time. She's taking too many bathroom breaks, and it's not good. It doesn't look good at all for the employer. And I think the other thing I will say is sometimes it can just show you why, or that these people are dug in for reasons beyond the injury. Maybe there is a history of some hostility between the parties, and that can just inform you that this case is going to maybe feel personal to both sides, not just your worker, but maybe there's an employer who's going to dig in for some other reasons. And that's just going to take a delicate touch. You're going to figure out what you want to do with that and how you want to work through it. But I think it's good to know that that's what's going on. And I love to find things like that so it can inform how we approach it.
Right.
Yeah, I had a kind of an interesting question. In the instances where you get some of the items when you sent your letter, Amanda, when you send a subpoena afterwards, do you get more, or do you get the same thing sent back to you again?
Definitely I've gotten the same thing. I've gotten a repeat production of the lacking file.
Yeah.
If I'm going to bother to reissue my new subpoena, I'm going to get more specific. I'm going to figure out the things that I actually am willing to litigate, the things that I think are necessary. So that might be like, let's say that my client is hurt by the machinery. I know that now. Maybe I want those maintenance records. They're technically should be there in my original demand. But now I'm going to specifically say, I want the maintenance records for all vehicles that were in operation from 2022 forward. And so now if I need to litigate it, it's a lot more specific. Their objection is going to have to be a lot more specific, and my judge is going to have an easier time deciding whether this thing that I want is discoverable. It is. And so it's just going to be a lot easier. So I would say not often I get it all the second time, but I'm going to get more specific, and it's going to make it easier for me to follow up on it.
Yep.
Jesse, does that sound similar?
Yeah, that's very similar. Back to your point about absences and write-ups and things like that. Sometimes you're absolutely right. They're tied into a 132A, because sometimes the absence is because they went to a medical appointment on this case. Or sometimes the reason why they're late is because they were at a medical appointment for the case, and the supervisors don't care. They'll write them up, and they don't realize that they're writing them up for something that, they have the right to be at that appointment, and that's why they're there. And so the other thing about employer files that I just remembered is that when you're dealing with huge companies or bigger companies where you have several locations, they might have more than one personnel file.
Oh.
It might be the line manager might have a personnel file, and then home office might have a personnel file. So they may not be sharing everything with you. They might be sharing you the one and not the other. Or they might have several locations. Your employee might have worked at several locations where you want them all. You want all the different locations because there's more information. That 300 form that we were talking about earlier, it's location specific, where accidents happen at different locations for the employer. So the employer has to keep that per location, not company wide, but per location.
Not cumulative. Gotcha. And one of my favorite people loves to ask questions. Brett Bora sent in one, and he says, when obtaining the claims file, I'll occasionally get correspondence with the defense attorney, or maybe even the reserve sheet. I know neither of you would never, ever read those. Do you return those to the claims examiner? How do you go about returning those to the claims examiner?
I've never seen one.
Perfect answer.
Yeah, I only saw the first line before I folded it up, put it back in the envelope, and mailed it back to them. But yeah, I'd love to return those. I'm happy to return those.
Yeah, I've had letters to, letters from the defense attorneys to their adjusters sent to me, and we sent it back. We sent it back.
Yeah.
I mean, unfortunately, sometimes we've already laid eyes on some of that information, but you send it back. You want to win honestly. You want to present your case properly, and there's no need to do anything otherwise.
Yeah. Another thing that I wanted to address, you mentioned it about how a common objection we might get would be work product, or they'll say, oh, attorney-client privilege. And I got some questions about that before the seminar, so I do want to address that. It's not work product if there's no attorney involved. There's no attorney-client privilege if you are an adjuster who works for a carrier and you write to your supervisor and say you're going to deny the claim because this guy seems like a liar. That doesn't work. You don't get to then say that that's prepared for your future attorney. It's not true. You can't do that. For some support behind that, I found some cases, and it said that in general, the WCAB and the California Supreme Court have found that most documents are discoverable, and that's going to be claim notes, investigation reports, witness statements, and other documents. Winchell's Donut House versus WCAB, the board upheld a judge's order compelling the defendant to produce records. The claims adjuster's notes were not within attorney-client privilege, although they had been used even in attorney consultation. But the board said that the notes were subject to discovery by an applicant, even though they were prepared for the purpose of defending against the claim and contained statements made by the policyholder to the insurer, as well as personal observations of the claims adjuster. So those are discoverable. You can get those. The objection that the attorney was involved is not going to fly. It doesn't work. And then I did find that in contrast, in the Coito Superior Court case, the California Supreme Court held that a witness statement obtained with an interview that an attorney actually did, those witness statements can be protected because there might be work product involved there, but it's not going to be automatic, and you can litigate it and you can ask for those things. And it just said, the last note, the actual subject matter may not be protected and could be discoverable through another means. So I think you talked about that earlier, like if you think there's something there, get that person on the witness stand, or asking them questions, or getting forms that you are entitled to that are going to lead to more information beyond their actual thoughts and opinions of the case.
Correct. Right.
Good deal. I think that is all the questions that we had for now. If anybody else has any other questions, go ahead and type them in. Jesse, any other interesting or fun things that you've ever found in a claims file that you didn't expect to find?
I mean, no, because I know what's supposed to be in there, so not something I didn't expect. But one thing I do want to warn is that, as a practitioner, you got to worry about going down a rabbit hole about litigating this on every case, because it's not cost effective.
Right.
But it is useful. If you need it, you need it. You need to litigate it. You go through your claims file, you go through the employer file, you gather information there. And if your case drives you there, of course, do it. You need to do that to protect the applicant and make sure they're getting everything they're entitled to. But you don't want to have this battle on everyone, because then your case is just going to be continuously set for hearing after hearing. Unfortunately, a lot of the judges just don't, they either don't know the rules with regard to, what we're entitled to, or they have a lot of other things to resolve on cases other than a dispute about whether somebody's giving something to you or not. And a lot of times in those hearings, what happens is the judges will just say, look, just give them the information, and it gets petty, and you gotta either be ready to go to trial on the issue most of the time, or let it go, because otherwise you're gonna go to a wasted hearing, because the defendants a lot of times just show up and they say, no, we're not going to provide it, or you're not entitled to it, and you're going to have to go to trial on the issue. So you have to be ready to do that, because if you don't, you're going to walk away after a hearing and you got nothing.
And I would imagine there's got to be economics involved in that as to whether it's, worth going down that road, right?
Mm-hmm.
Any idea on a size of a case that you would say?
I wouldn't make that decision based on
the facts.
I mean, if the facts lead me there and I need more information, and I know there's something going on, my client's telling me something, and I need that piece of information, I know it exists, I'm gonna do it. But rarely am I looking at, it's a big case or a little case. I need to process and get the information so we can get the correct medical, we can get the correct information, we get, the claim can be admitted, need to get the applicant treatment. I mean, all the numerous problems that we have on our cases. Typically that's the driver for me. But I've gotten into some of these battles, and some of them I end up and I go like, wow, I just wasted a lot of time and just got one little piece of paper and it wasn't that big of a deal. And then on some of them, it's been fruitful, and on some of them it drives settlement too, where they just want to be done, and it'll drive settlement on the file. And sometimes I think the adjuster knows maybe they withheld some information. They don't want to be called to the stand, and you get that settlement.
I can see that happening. Yeah. Very cool.
Yeah. Brett has a question for Gemini. Maybe you know the answer to this. In your subpoena form, does Gemini have a standard request? Could you simply say, get me the claim file, or how much detail would you need to include?
I'm sure I have some account managers and customer service reps that could tell me that answer, but I don't know myself, but I will follow up on that. And I'll include it in some follow-up materials to everybody that I get out.
Yeah, I'll just tell you from my practice, I think the claim file is pretty generic. I think they should know what it is, but I don't think they do. I think that you give them the out to say like, oh, this is the entitled claim file. I think you have more success by listing the things you want and just make it a copy paste thing for you. Make it a form that you have. I like to attach my demand letter because it's so detailed and it lists everything out. And then, like I said, usually my subpoena is a follow-up with the real specifics of what I'm looking for, which is most commonly, almost always, the main things that I'm getting that I don't really have. It's wages stuff, and it's like maintenance-y stuff if I'm trying to figure out like a specialty case, like a 132A, serious and willful. Those are the most common additional subpoenas that get issued for me.
All right.
Material safety data sheets a lot of time are hard to find. Yeah. Those
I'm sorry, what was that, Jesse?
Material safety data sheets with
Okay.
types of chemicals and things like that
Yep.
are being used. They can lead to injuries that you're unaware of. I mean, honestly, I agree with Brent. You should just be able to say claims file. There's a code section that says what's supposed to be in the claims file. Everybody knows what's supposed to be in the claims file. It's the claims file provided.
Yeah.
But if you do that,
Right.
you're going to get, oh, it's too broad. So you have to be specific.
Do you specifically request the 10109 file is the question that I got.
Yeah, I mean, I don't hate that. I don't hate just saying like, claim file as interpreted by 10101.1.
All right.
That is it's a 16-point list, and they're going to have a hard time saying they didn't know what was included in that list, especially since it's a regulation.
And the powerful thing about doing that is that if it's something on that list and they didn't provide it, and then later you get it, then that's a problem for them. So.
And one of my guys chimed in and said, yes, we have standard language. So nice.
You do.
Yep. Yeah. And then Dennis Thomas did ask, why is Brett Bohr asking all the questions? Very nice. All right. So anything that you'd close with, Amanda, Jesse?
I think Jesse definitely nailed it when he was saying like this, we're giving you all of the information that you need, but not for all of your cases. We're telling you this is options that you have when it calls for it. And to be successful, it is about identifying when and where to push, and what kind of things that you need and when to take it to trial. And it's going to be a judgment call in your practice style, and you have to figure that out for yourself, like when you're going to make something of it. And I think that takes time to figure out, but I also think just subpoena a few when you're first starting out and figure out what you're missing on some of your other files, and that might inform your decisions moving forward.
Right. The thing I would do as well is train your staff to look for these things, because you don't have time. And so if you have a good list of like what I like to do is keep a list of different documents, and then underneath the document, what information is in that document, so that I can have my staff look for it that way. And so when we run up on the piece of information we need, we can say, okay, well, what documents would be in the claims file and the employer file that would have that information, and then you can cross-reference that. And it makes it easier for you if your staff are looking for those pieces of information and not you. They'll find it quicker than you anyways, because we look at our files and we go down rabbit holes and look at a whole bunch of other things. But if you send them to look for one piece of information, the date that this happened, or was there a machine involved, and there's just different forms that you can find that information, then you can just go straight to that form, figure out that information, get a yes or no immediately, and then you can start doing the digging and doing the lawyering. But if you can distill it that way, where you write down the forms where the information is at, and list that information, you can always go back and do that. If you can organize it that way, that'd be the best.
Yeah, and by setting the automatic look for the claim file too, like, by just saying it's going to be 30 days. And I didn't mention this, but I don't reach back out to them. There are no second chances with me trying to subpoena it. They were given the demand letter, the time has passed, the subpoena issues, and that saves us time and resources too. My paralegal knows when that deadline comes, she looks for it. If there's no claim file, she issues the subpoena. She has the list from my notes. She knows exactly what she needs to look for in the file. And then we go straight from there. We don't call them and ask them about it again.
You don't do the pretty please call?
Not anymore. Yeah.
All right. With that, I'm going to go ahead and wrap up. I want to thank both Jesse and Amanda for agreeing to come on and give us their time and their expertise on the subject. Thank you all for coming, and you will get some more email follow-up information, both on the MCLE credits and also on a couple other follow-up things that I want to send out.
Yeah, and I just, in the Q&A box, the answered section, I typed out all of the cases that I gave. So if you want to screenshot that or
Cool.
jot it down, then feel free. It's in the answered tab.
Oh, there we go.
Great. Thank you.
Good
Thank
deal.
you.
All right. Let me screenshot that, and then I'll have it to be able to send out to everybody.
Oh, perfect. Thank you.
Yeah.
Okay, and I'm always around, so feel free to email me. Like, I have a lot of free time, but I do, and I'm happy to help anybody that has any questions. If you felt confused, feel free to shoot me an email or ask me a question.
Me too.
All right, good deal. Well, thank you everybody for joining, and have a great rest of your day.
Okay,
Thanks.
Thanks.
Have a great day.
bye.
All right.